Welcome to Cooper's Code. We are doing the AI overview in terms of AI and the law. It shows up about every month or so, and I'm thrilled to be here with co-hosts Shahrad Milanfar and Marshall Cole. Shahrad's up from the Bay Area, as people know, plaintiff's personal injury lawyer, a reformed defense lawyer. Marshall Cole is from the LA area, and he's the kind of lawyer that most lawyers want to make sure they never need. Esteemed legal mal-defense lawyer. So all of us, though, have a vested interest in technology and use of AI and keep current, and want to make sure that everyone out there has the opportunity to keep current as well. So Shahrad, I might kick it to you. I know we've got some bullet points to cover, but the hallucinations in everything from pro per loss to pro per win to mega firm taking it on the chin. And where do we go from here?
So it seems like there's a range of issues that have occurred that kind of change the perspective of this kind of mistake is being made by, solos or improper plaintiffs. So we have a case in Alameda County where the judge dismissed the case when the proper plaintiffs, and that, for those of you who are not lawyers, are people who are representing themselves, submitted fraudulent evidence to the court, and the court basically dismissed their case because of that. We also have a very esteemed firm, Boise Schiller, that recently made some filings, that at least one filing that was containing hallucinations, and they're in hot water because of that. So now there seems to be a range of people who are using AI for legal tasks and are not necessarily doing the vetting. But on the other hand, I recently saw a story about an improper who beat her landlord in a landlord-tenant case, likely an eviction case, using AI. And that was kind of a fascinating approach that she had used to minimize potential hallucinations when she was filing documents with the court. So it's kind of few things to throw around.
That last one was the one I think that might deserve the most unpacking. I think that the takeaway from my perspective on the hallucination side is if everyone is getting tagged by it, it means that we need to do our best on quality control. And if a firm like Boise Schiller is getting tagged, that tells me that I need to make sure that if somebody's giving a brief to me, that I've taken a look at it, that if there's a case that seems like it might be a little bit too good for us, that it gets vetted. But Shahrad, I thought what this pro per did was brilliant. Do you want to share that?
Yeah, and going to your point, it doesn't seem to be an issue of resources, right? Because if this mega firm that has all these esteemed lawyers in it falls into the same trap, it's an issue of, are people just stressed and just wanting to get something off their desk, or they don't have time to vet it? And that's where I think the pitfall is our human nature to not necessarily pay as close attention as we should. And I think everybody has the potential for that mistake that we just need to be hyper vigilant about.
With somebody with the depth that Marshall has, when a lawyer comes to you and says, I'm worried about my firm and my exposure, how do I have best practices to reduce my risk for AI use? Because I don't know if a paralegal is using it, and I do try and do my best for checking things. That's one, and two is, if I do end up making a mistake, what should I do to fix it? Do you have any recommendations in that regard, Marshall?
Yeah, on the first one, when it comes up all the time, I say you should have a policy in place that creates boundaries for your staff as to when they can use it, how they can use it, et cetera. And if they are doing it, they should provide training and force people to read these articles, because it seems like since we've been doing this each month or so, there's a new firm that this happens to. Every month, it's a new one. And I agree, it's kind of now run the gamut from mill PI solo to reputable, very reputable firms. And I think that it's, and as Shahrad was talking, I was wondering, when the lawyer who did that in the Boise Schiller matter, was it just sheer laziness, like really trying to get something off their desk? Because if you're actually doing it right and trying to get correct and accurate case law, I wonder how much time you're actually saving than just doing those searches through Westlaw, which is still really efficient legal research. And, sure, you can definitely get cases quick, but if they're not accurate, then forget the risk component, but you're also just not actually saving any time. You've created something that's fake. So that's worthless. But if you're going to do it right, it might have taken more time, right? You might have to go and vet the cases. And also, if you have to go and vet the cases anyways, again, are you saving time versus just doing it properly through Westlaw or Lexis or whatever it might be? So I think those are the interesting parts of what's going on here. And people I don't think are thinking thoroughly is this really beneficial to me?
Shahrad, we'll come back to the pro per piece. I haven't dropped that line, but this reminded me of, there's a personal injury firm down in Los Angeles that does very high-end work. And when I was a young lawyer, I had heard that they had, in essence, a New Yorker style fact checker. So they have an editor whose sole job is, before any meet and confer, any brief, anything goes out the door, that person has to go through it and review it, and any citation in it gets QC'd. It seems like a lot of effort to have one person on your staff who's just doing that. But that to me sounded like a great threshold, and it is something we use a variant of that, where if somebody writes a brief, somebody else goes through and tries to poke holes in it to try and find something wrong with it before it goes out the door.
Just as a side note, I was talking to a friend of mine who told me that one of our mentors had a job with a very prominent defense firm. And his job was, when they needed to cite to an article about something, he would write that article and then they would cite to it. So kind of the flip side of that coin.
I like that.
Yeah, that's a good one.
I buried the lead a little bit, Shahrad, in terms of the pro per who is using a tool that might put us all out of business if somebody keeps doing the anti-hallucination method.
So this was on a news video that I saw. Basically, this lady supposedly beat her landlord, I'm assuming in an eviction case, and she did it by using AI in this way. She would go to one system, put in her prompt, get the response back, and then would take it to go to the second system and enter the response and have it vet the response, and then take that response to a third one and have it vetted by the third one. So that, it seemed to me, significantly reduced the chance of hallucination and made it so that whatever she was submitting passed muster, and she apparently won the case, according to the news report.
It's an interesting approach. Marshall?
I think that approach is great for someone who doesn't have a law license, right? They don't have a way to know, because the only other thing they could do is Google it, right? So if they're just Googling these cases, presumably they exist, but maybe they don't at this point, and they don't know one way or the other. So she's still taking a calculated risk regardless of just having one system vet the other and then another vet those. But, she did it to a level where she's comfortable. And also, there's the repercussions if there were hallucinations are much different for her than there would be for any of us or any licensed lawyers out there. And then lastly, it kind of goes back to the point I made earlier, which is, if that's what you have to do in order to make sure you're not getting hallucinations, you probably could just do the research in the same amount of time from, just the legal research perspective, and ensure that you're getting accurate information. I mean, I assume she was having to draft entire briefs for her, which is great. And I think it does provide a huge benefit to people who don't have access to a lawyer, who can't afford a lawyer, from what they would have been filing before to what they can file now. Excluding case law, just draft me an argument, on these subjects or on this issue, or here's my 5 facts. It's going to do a phenomenal job for those people. And I do think that they're going to see better results against these types of matters, landlord tenant matters, small neighbor disputes, whatever it might be. I think they're going to be very well off.
I'm bouncing around with a very unsmooth segue to a different topic. One of the notes I have in terms of conversations that we had was something related to frontline managed services, and I have a note, Shahrad, that this may have been a entity that you mentioned at one point, an AI tool that produces billables by sitting in and monitoring all email and workflow. Does that ring any bells to you?
I don't know if that's the company. I think the company I saw was something like Meantime or something like that. And
Okay.
they log into every system that you have, and then they can monitor every second of your life while you're working. And I haven't tried them. I don't know anything beyond that, but it seems like they were pitching to people who do hourly work, saying, we'll make it a lot easier for you to keep track of your time by automatically essentially creating these time entries for you.
Marshall, have you come across anything on, because I know you do some time billing.
Yeah, I do. And I was reading about it, and we don't use it. And I would not be going to rush to sign up and pay money, to allow this company just unfettered access to my firm's email system. And I think any of these, when you start allowing that type of access, you got to do your first question was security. But beyond that, I think it presents an issue for me as far as overbilling, right? I mean, just because I get an email doesn't mean I bill a 0.1 or a 0.2 or a point whatever. It may not warrant a time entry. So for it to just create entries because it sees emails, and how long it would create that time entry for, it seems really suspect as well. Because some people read faster than other people. I mean, we have to bill the amount of time that we spend on the particular task. And so those are my issues with that type of, advertisement and allowing it to do that. Sure, it probably could go through my emails and create 0.1s all over the place, but I don't think that's how I bill my time. Most of those emails don't get billed.
Well, I recognize that the majority of our listeners tend to be more on the contingent fee side, and so time billing is less interesting. I do know that some contingent fee firms keep track of hours to help them understand how much time they put into a matter, what cases create value, what cases don't create value as they go forward. And so I know that when people are looking at how to be efficient on that, efficiency is important. But as you point out, Marshall, so is security.
We keep time because some of our cases are cases where we can file attorney's fees motion on, right? So it's important to have accurate time and be able to do that. But again, every phone call is not something that is billed, and every email isn't billed. We try to put our time entries in a way when if a judge looks at it, they're looking at it that this is billing for serious work that's being done that advance the case to the point that it got to, as opposed to just, hey, we're nickel and diming this with every 0.1 entry that's conceivable.
And presumably you could create, I'm sure they can set it up to try to be as efficient as possible, but it's one of those things, and maybe this is a little bit naive to say from an AI perspective, but it just seems to me that's one of those things that requires a personal touch. I read my emails different than my partner right next door reads his emails, or my associate reads her emails. And they all are expected to bill based upon that. And so it's so personal, and it requires an exercise of judgment, whether I'm going to bill it or not, that I don't think can be captured through an AI platform. That's how I look at that one.
That makes sense. The security piece brings me to a separate but related, and I don't know that I'd necessarily categorize it as security, but the idea of having data about one's clients accessed by other sources. And without using names of entities, I know that it has come up, and I believe, Shahrad, you brought this to our attention, that some of the companies who are offering services out there, say for demand packages or other places, are both doing a good job of providing the demand package drafting, but also offering a kind of a back end where they're gathering data on what the resolutions are, with the expectation that at some point they're building some sort of Colossus variant. Do you have any more insight on that, Shahrad?
Well, I actually did speak with an executive at one such company who has now told me that they are discontinuing, or they have discontinued that practice because it wasn't really getting them the data that they needed. So I don't know what that means. But as of right now, that company is no longer offering that incentive of tell us what your case settled for, and we'll give you some additional credits toward our service.
That I think answers the question, but I don't know that long term that it necessarily closes that arena. And I think we've talked about this a little bit in the past. Colossus being the database that insurance companies use to tell you that your case is worth $1,347.62 based on similar incidents across the country. The more granular this data gets, and the more AI can do data analysis and data science, the more it seems like we're going to start getting big data feedback on valuation on cases.
That's an interesting concept because there are now firms out there that are doing big data analysis on jury results. And there's apparently research that was done that indicates that AI is actually notoriously bad at predicting the results. And one of the researchers who was giving a presentation at a conference that I went to indicated that there was one of the AI models initially was fed the information and said, this case is worth $250 million. And then they said, well, can you tell us how you got to that number? And the response came back, oh, thank you for pointing that out. I've reevaluated it and the case is worth 1.2 million. So that's a huge variance. And he used that as a very extreme example of how it got it wrong. But for the most part, they were saying that the AI itself is really poor at determining what the case value is. And quite frankly, we've talked about this, Miles. I think the idea that somebody else got a $100,000 verdict on the same case and that somehow drives my value, your or Marshall's value is absurd, because there's too many variables to say, yes, this case is instructive in terms of what the result is going to be.
And in the instances that I've actually done it, I've had some trials come up and I've just been curious and using it as an opportunity to sort of try and learn, hey, what might a jury be likely to do in these circumstances? And without coaching it, it's really bad. But the second you start to say, well, would a verdict of this number or a verdict of this number, or what about these defenses? It's like a golden retriever. It then just starts to want to please you, and it understands where you're going. And so then you're just getting kind of what you want, but I don't think it's accurate at all. And so, because it'll be like, oh, yes, I could see these defenses being really strong after I've pointed those defenses out. And then I can ask for the weaknesses of those defenses, and then it will point out the weaknesses of those defenses, but it didn't do it beforehand. And so, sort of like just telling me things I already know, and wasn't very useful in helping me try and learn something new or come at something from a different direction, like as if I would be dealing it with the jury. And I think a lot of that is just like trial lawyer experience and that true human connection that you try to make with jurors. To your point, Shahrad, that like just because someone got 100,000 in some jurisdiction doesn't mean on the same facts, same case, could be like everything identical. You bring a totally different flavor to your case with 12 different people, you can get a completely different result.
Yeah, I just get tired of hearing from, opposing counsel, you're not Miles Cooper or Marshall Cole when you're trying cases. So
A variant, I think, of what we're talking about. At one point, our firm tried using a Monte Carlo simulator for analysis for our portfolio for the bank. And I think most people know this, but on the contingent fee side, if you're using a line of credit, your bank wants to know what the value of your cases are. And so, usually once a quarter, once every 6 months, you provide an estimate to the bank of these are the X number of cases that I have, and by name, here they are, and this is when I think it's going to resolve, and this is how much I think it's going to resolve for in terms of the net fee. And a Monte Carlo simulator was a very fancy spreadsheet that was pulled together that kind of gave a high end and a low end on what those estimates would be, run through multiple times and what have you. And our takeaway after having played with it for about a year and a half was nothing beat our, whether you call it gut instinct, limbic system, 25 years of seeing how cases turn out. We were always pretty much spot on valuation. We were always about 6 months to a year off on how long it was going to take. We knew those challenges, so we adjusted for them. And my takeaway from this was, after doing this for as long as we've done it, we seem to be better than machines on the gut instinct valuation. And I don't see anything so far that tells me that that's going to change. And I think I'm just saying a variant of what you, Marshall, and Shahrad both said.
I think you're absolutely right on that, because there's too many variables, right? You change a few jurors in that same trial and you may have a different outcome. And we know that from talking to our jurors at the end of our trials. The one thing I've found that it's interesting to do with the AI is our practice management system just had a new release and rollout of an upgraded AI system, and it's a significant upgrade. So I have a case going to a mandatory settlement conference. So I took both our statement and theirs and I put it in. And I said, all right, review this as an expert. Do an analysis of the strengths and weaknesses of both sides, and what can each side do to like bolster their arguments and that sort of thing. And it actually did a pretty good job of giving me an honest and balanced analysis of the weaknesses in our case and weaknesses in their case. And at the end of it, it said, which maybe was the part of the people pleaser piece of it. It said the defense seems to be underestimating the value of the severity of the damages or the injuries that your client sustained. So it was an interesting piece of feedback, but in my opinion, it's only a data point, right? Because to me, I want to talk to other human beings who look at my case and say, well, okay, so what? Or, oh my God, that's horrible. How can this person be put through that? Those are more instructive, in my opinion, than having a machine kind of give me what I may want to hear.
Sometimes when you are in cases and you keep hearing from defense counsel and adjusters about how terrible your case is or how they're going to win or how they've had 8 other cases like this and they've defensed them all, you start feeling a little bit like, oh, well, I must be seeing this wrong. And the answer is no. If you're in the game, if you're working with your colleagues, if you're spitballing the case and roundtabling it with friends, and everyone's saying like, no, they're missing something. Each case is unique. These are humans going through human experiences.
Fortunately, defense counsel put that in writing in that same case, saying that he was going to win and, quote, see you at trial. So I really thanked him for putting that in writing and guaranteeing the win on an open policy case. So.
Yeah. I think it's important outside of the AI side of things, on the trial lawyer, the litigator side of things, is to have faith in one's ability to analyze a case and move forward on it, even when the defense is telling you how they're going to crush you 8 ways from Sunday.
And if you don't have an idea of that and haven't learned it on your own and are relying upon AI for that, I think like get ready to lose, or get ready to have a number that you're not going to be happy with, because without the ability to independently analyze it, take it as a data point, like you said, and consider all the other factors, including who the lawyer is on the other side making that chest pounding statement. I mean, it could be the worst lawyer ever that you're not worried about it, or the best and say, well, he's going to do a really good job, or she's going to do amazing. So whatever platform you're going to put it in isn't going to know or understand those aspects.
Well, and that's an excellent point, because if the AI or one data point is a determining factor in how you value your case, maybe you need to refer that case to the lady who beat her landlord as a pro per. I mean, you're basically taking the human and your experiences as a human being out of the equation, which to me is the worst possible approach in evaluating and advising your clients.
That's what I really like about what we do versus other industries, at least from litigation, right? We're in court, different than transactional lawyers and things like that. And certainly different than people in finance, where it's very data driven. There's a lot of objectivity to it. It's black and it's white. I mean, the three of us, deal in so many shades of gray, and never is something black and white. Right? I mean, it's just very, very rare. And so, once you decide it's gray, right, it's just what shade of gray. And I think that's where the skills that you develop as a trial lawyer, if you're going to be in court or writing legal briefs, requires the understanding of all that nuance that goes along with it, which is very, very important. And I think in the times I use AI to try and get that type of experience, it tries its best, right? It does, I get some value out of it, but it's because I know what's valuable and what's not. And I know how to input the data in the first place, all of which is built upon those years of experience, reading judges, being in front of judges, understanding all that nuance that it certainly can't do because it just doesn't know those people or how they play a role in whatever we're doing.
And going back to the idea of knowing your cases, for younger lawyers who are listening to this who haven't had that experience and who may be more inclined to rely on ChatGPT or Claude, a reminder that one of the great things about the plaintiff's bar is that almost all of us are willing to help each other out, meaning a phone call, having some people over to lunch, doing it in person and spitballing a case. I mean, I learned valuation on cases from hanging out with great lawyers. And now I feel I have a pretty good valuation. Even with that, I'm likely to call up or get together with a few of my friends to spitball a case if I've got questions about it.
I appreciate the inference there that the defense bar does nothing.
Well,
which is sort of
and this, I've never worked the defense side. What I hear from the defense side is the plaintiff's bar is so collegial and so willing to share things with each other that you make it hard for us on the defense side because we don't always do that in the same way. We don't have the listservs. We don't have the deep social connections in the same way. And maybe I'm wrong, Marshall, but that is what I've heard.
No, it's totally accurate. And we try our best. I think you all are a much tighter organization. The listservs are much larger. I completely agree for younger lawyers to take advantage of all that stuff. We certainly have it on the defense side. It's just not as expansive. I mean, the membership is not there, but we certainly do our best and share what we can. But no, I agree with you on your side of the aisle. It's tremendous.
I will put a little caveat out there about the listservs. Listservs are a great place to gather information. I've shared this story more than once, but it's worth sharing again. They are more porous than one might think, and so do not list your entire. I have a case with blah, 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 blah against so-and-so and so-and-so, and my client is willing to settle for X. If you do that, there's a reasonable chance that might find its way into the wrong hands. And I share this only because this was probably 20 years ago. I posted on the listserv asking for feedback on judges in San Mateo County. The next day at trial call, I see the defense counsel flipping through some pieces of paper, and it's printouts of the emails from our listserv with the conversations about the judges. Yeah. A friend of his knew he was going to trial. It was no malicious piece. A friend of his knew he was going to trial in San Mateo and says like, oh, well, this might help you out. So, yeah.
Well, having been on both sides of the aisle, I agree that there are certain factors on the defense that make it a lot harder to collaborate and help each other out. And that's a much longer conversation. But what I found on the plaintiff side is, you're right, there's so many people willing to help. But I also find that I can call my friends on the defense and run stuff by them, and they call me to run stuff by me. Just a few days ago, a friend of mine, he has a very serious case on the defense side. He called me up. He's like, what do you think? And I gave him my honest evaluation in terms of the strengths and weaknesses of his case. And those are things that the individual relationships built for us, where a computer can't simulate that sort of interaction. And for me to call you guys and say, hey, I got this issue. What do you think? Am I just totally off base? Or do I have a reason to believe that this is a good approach that we're taking are hugely valuable. And for young lawyers, build those relationships, get mentors, and call us, call other people, because people want to help younger lawyers get better, because that's how we end up with the profession sustaining and being a solid profession, as opposed to everybody keeping their knowledge to themselves and not really helping the younger generation come up.
I do think that, as Marshall referenced, I think the golden retriever earlier, if you are running this by your AI thinking partner, there is a substantial risk that it's going to give you false hope because it wants to please. Anything else that people think is particularly timely that we should cover before we wrap for this month's session?
One other thing is, and we touched on it earlier, maybe before recording, or I don't recall, but is sort of the AI fatigue. And obviously we're hearing about it, we're using it. But I think it was Miles, you were saying that most people are not finding it actually to be effective and either saving time, or they just don't know one way or the other. They're just using it blindly.
There's a study that people have been citing too, that 95% of the industries who have implemented it in some fashion are not finding a meaningful increase in productivity. Forgive me, I don't have the site off the top of my head. And so that's, I think, something that's percolating in the back, along with the conversations about AI bubbles and circular investing. So, but I cut you off, Marshall. I'm sorry.
No, that was it. And I just think it's really interesting. And for our industry, when we see at least once a month, almost, a new firm or incident with people doing something wrong, how long until people say, I'm not going to risk it, right? I'm not going to do it for at least litigation purposes. Or B, it's just actually not saving us any time, and it's not worth the monetary investment. And so it'll be interesting to watch this develop over the next couple episodes, because I'm sure it's going to just morph into a large topic just as these things continue, because I sort of optimistically expected those horror stories of hallucinated briefs to go down, not up. Right? Like, there's enough journals out there, daily journals, newspapers, friends talking amongst friends, listservs, right? Where this gets brought up, and it's just a reminder of how many lawyers there are out there. But I just would have thought it would have been nipped. That would be it. You wouldn't see it anymore. And for us to be here at however many episodes in, continually talking about a new one, is surprising to me.
I do think it is, but while it's wise to be mindful about the uses, I do still like using Claude as a thinking partner. I do still like throwing things in there, iterating on strategies about cases. It's sometimes there are things that get thrown up that I don't know I necessarily would have thought of, but there is a risk of parking your brain if you just rely on AI. The AI summary of this episode is going to say that we are down on AI because we spent most of our time talking about getting together with colleagues and how AI is not as reliable a resource. I do think it still has utility and relevance, and you need to make sure that it's being done in a right fit way.
I think if you would read the summary from most of our episodes, it would read that way. But it really isn't the case. It's just sort of like, just exercise extreme caution and it can do amazing things.
Well, it's kind of like exercise, right? I want to be able to do 50 push-ups in a row, but I don't want to do the work that leads to being able to do 50 push-ups in a row. And with AI, people are saying, well, it's not increasing my productivity. Well, the question is, how are you using it? How are you investing some time in the beginning to set it up so it actually does what you want it to do in the way you want it to do it? And those are all important things that we have to consider when we're evaluating whether or not AI does help us or doesn't help us. But like you said, the MIT study that you pointed us to about how that's affecting, people's mentality and how we're looking at this. This isn't new because there was another study that was done and they found that if you have your phone sitting in front of you on your desk versus behind you versus in another room, you're more focused and effective when the phone is no longer in front of you and it's in another room. And that just tells us that our brains are wired to constantly seek this stimulus that the phones and technology provides. So how do we use that knowledge to help put our process in place in a way that allows us to gain maximum productivity versus allowing us to spin our wheels and say, oh, well, you know what? I put this prompt in, it gave me garbage, and it's terrible. I don't want to use it anymore.
Just a tangent on your comment about the phones. I won't be able to credit the origination on this, but somebody referred to it as an adult pacifier. And I thought that was about the most apropos thing I think I've heard in a long time. I'm not feeling great. I'm going to grab my phone.
Well, all you got to do is look at the stats at how many times a day we pick up our phones. It's insane.
Yeah. As always, I love our conversations. I love the work put into beforehand because it helps me stay current on all these things. So thanks for joining us, everyone out there. For all of you doing justice out there, happy hunting. If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions you have for who you'd like to see on the show.